Hello, my name is John Milburn. Today I'd like to speak to you about Commonwealth lawmaking environmental powers. The Commonwealth has no direct power to enact laws for the environment. However, the federal government does make laws with respect to the environment, and it does so largely by using powers conferred upon it through Section 51 of the Constitution. The celebrated Tasmanian Dam case, which is the Commonwealth against Tasmania, 1983 158 CLR 1, revealed the Commonwealth's ostensibly limitless capacity to override state laws by adopting environmental treaties via its external affairs power. When doing so, the actions of the federal government are subject to close scrutiny by state governments, and during the 1980s in particular, the state governments challenged a number of federal laws that related to environmental lawmaking on the basis that the federal government had no power to legislate in that area. But following a spate of constitutional challenges which were unsuccessful, on the 31st of October 1990, the heads of government of the Commonwealth, States and Territories of Australia and representatives of local government met at a special Premiers' Conference in Brisbane to seek to resolve issues pertaining to environment in a more cooperative manner. And that conference led to an agreement between the Commonwealth, the States and Territories and the Australian Local Government Association. And the document was signed in 1992 called the Intergovernmental Agreement on the Environment. The preamble to the document indicates the purpose of the document is to reflect what the parties have agreed to in terms of developing and concluding the agreement by mechanisms which seek to foster and facilitate a cooperative approach nationally to the environment, a better definition of the roles of the respective governments, a reduction in the number of disputes between the Commonwealth and the states on environmental issues, greater certainty of government and business decision-making, and better environment protection. It acknowledged the important role of the Commonwealth and the states in relation to environment and the contribution to the states through developing the policies for which the Commonwealth had responsibility. In essence, the document provided a workable model to allow efficient and effective administration and political processes and systems for the development and implementation of environment policy. So rather than litigate in the High Court, this document provides an acknowledgement by governments as a way of acting cooperatively with respect to environmental issues. The background that led to that situation can be traced back to a number of important decisions. One of those was Murphy-Orr's Inc. Pty Ltd against the Commonwealth 1976 CLR 1, where the High Court determined that if a law falls within the subject matter of Commonwealth decision-making, then the law is valid, even if it relates to environmental matters, which is not directly contained in Section 51. There are a number of powers enumerated in Section 51 of the Constitution that the Commonwealth has subsequently relied upon to support environmental laws. So the most notable of those, trade and commerce power, which is subsection 1, financial power, subsection 2, fisheries, subsection 11, corporations, subsection 20, acquisition power, which is subsection 31, probably the most important, subsection 29, external affairs powers. And when I talk about those subsections, if you look at section 51, you'll see that those subsections are in Roman numerals. I mentioned subsection 31, which deals with the acquisition power, and that brings into play the whole concept of acquiring property on just terms. And the Commonwealths and states have worked together to satisfy requirements in relation to acquisition of property from people on just terms. However, it's not an easy area of practice and it needs consideration of case law. I'd recommend that you start by looking at in mutual pools, Pty Ltd against Commonwealth, where the High Court determined that there must be at least some obtaining of an identifiable benefit or advantage. What the High Court was saying is that some form of sterilisation or deprivation or even modification is insufficient. There must be something which has been acquired in order to trigger a claim for compensation. What the High Court were doing in that case is highlighting the difference between property rights and permissive rights. And a licence is an example of a permissive right. And that will not generally be sufficient to trigger a claim for compensation. It may give alternate rights to damages, but not compensation under the Section 51, subsection 31 heading. So have a look at the terms of that constitution, have a look at that case and some other cases. In particular, have a look at Bates, and that's Bates Environmental Law in Australia, which deals with a number of important topics in this regard. The Commonwealth has the additional powers to rely upon Section 92 of the Constitution to make laws in relation to Commonwealth places. Section 52 gives the Commonwealth certain powers to exclusively make laws in relation to all places acquired by the Commonwealth for public purposes. And bear in mind, of course, that when you're considering the interplay between Commonwealth and state or territory legislation, that Section 109 of the Constitution provides that to the extent of any inconsistency between federal and state or territory legislation, the Commonwealth legislation will prevail. Thank you for listening.